Hello everyone, welcome back to India4IAS. My name is Shreyas. So in this video, we'll be discussing Polity PYQ questions of the year 2022. So previously, now ಬೇರೆ year ಕೂಡ already discuss ಮಾಡಿದೀವಿ. So likewise, in this video, as we proceed, what are the things that we'll be doing? We'll be doing three things. One, how to answer the question using the limited knowledge that we have. Second, how to answer the question with the traps by identifying the traps and using the guesswork that we have learned. Third, along with answering these questions through knowledge and guesswork, along with that, we'll be learning the static concepts which become important for the subsequent years. Tumba sati 21, 22 ಅಲ್ಲಿ ಕೇಳಿದ ಕ್ವಶನ್ ಅದರ ಆಪ್ಷನ್ ನ ಪಿಕ್ ಮಾಡಿ 23, 24 ಅಲ್ಲಿ ಕೂಡ ಕ್ವಶನ್ಸ್ ನ ಫ್ರೇಮ್ ಮಾಡೋ ಚಾನ್ಸಸ್ ಇರುತ್ತೆ. ಸೊ ಲೈಕ್ ವೈಸ್ ಪ್ರೀವಿಯಸ್ ಇಯರ್ ಕ್ವಶನ್ಸ್ ಸ್ಟ್ಯಾಟಿಕ್ ಸಿಲೆಬಸ್ ನ ಮೇಲೆ ನಾವು ಸ್ಟ್ರಾಂಗ್ ಹೋಲ್ಡ್ ಇಟ್ಕೊಂಡ್ರೆ ಇಟ್ ವಿಲ್ ಡೆಫಿನೆಟ್ಲಿ ಬಿ ಹೆಲ್ಪ್ಫುಲ್ when we attempt in the year 2026. So with this, we'll start the discussion. First question, consider the following statements. Question number 1, consider the following statements. Pursuant to the report of H.N. Sanyal Committee, Contempt of Court Act 1971 was passed. Okay. Constitution of India empowers the Supreme Court and High Court to punish for contempt of themselves. Constitution of India defines civil contempt, criminal contempt. And statement 4, in India, Parliament is vested with the powers to make laws on contempt of court. ಈ ತರ ಸ್ಟೇಟ್ಮೆಂಟ್ಸ್ ಇದ್ದಾಗ ಫಸ್ಟ್ ವಿಲ್ ಟ್ರೈ ಟು ಐಡೆಂಟಿಫೈ ದ ಥಿಂಗ್ಸ್ ವಿಚ್ ವಿ ನೋ. ವಾಟ್ ಈಸ್ ದಟ್ ವಿ ನೋ? ವಿ ನೋ ದಟ್ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಆಫ್ ಇಂಡಿಯಾ ಎಂಪವರ್ಸ್ ದ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಂಡ್ ದ ಹೈ ಕೋರ್ಟ್ ಟು ಪನಿಷ್ ಫಾರ್ contempt of court. Article 129 for Supreme Court and Article 215 for High Court. Constitution has given this power for only Supreme Court and High Court. See, subordinate courts, they are not empowered to take action on contempt. Only the Supreme and the High Court can. So, idu correct annadu gottu. So, that means C is eliminated, D is eliminated, A or B. So, statement 1 ಬಗ್ಗೆ ನಮಗೆ ಗೊತ್ತಿರಲಿಲ್ಲ, but from these options we get to know that statement 1 is correct. Look at the third statement. Constitution of India defines. We have spoken earlier also, whenever the term Constitution of India comes, most of the time UPSC has made the statement as wrong. It is telling Constitution of India defines civil and criminal contempt. Constitution of India does not define it. It only mentions. It is defined in Contempt of Court Act 1971. So 3 wrong. Anyway, it was not needed. In India, Parliament is vested with the powers to make laws on contempt of court. This is correct. See, Parliament is vested with the power to make law on any subject. Ee tara kottag mostly correct irutte because Parliament has very broad range of powers it has a very broad jurisdiction when it comes to making laws. So Parliament has the power to make law on so and so subject anta kottaga most of the cases alli it will be correct. So the answer to this question is 1, 2 and 4. So contempt of court, very important thing. Constitution only mentions about contempt of court. It does not define or give categorization as civil and criminal contempt. So contempt of court, 2 categories ide, civil contempt, criminal contempt. So what are each of these? All these things are defined in Contempt of Court Act 1971. Another important note that we need to make is H.N. Sanyal Committee was the committee which made recommendation on the basis of which Contempt of Court Act 1971 was formulated. So civil contempt antide, criminal contempt antide. A court gives a particular order and if the person does not follow it, then that will lead to civil contempt. But if a certain person, he obstructs the administration of justice, or if he tries to lower the respect of the courts, then that would fall under criminal contempt. And all these things are in detail dealt with Contempt of Court Act 1971, whereas Constitution just makes a brief mention about it. See, Contempt of Court Act, it acts as a restriction under Article 19(2). It acts as a restriction on freedom of speech because the rights of the constitutional rights under freedom of speech, it is not absolute. It is subjected to restrictions. So kinds of contempt of court, civil, criminal kuda ide, and Parliament is empowered to make the law, and this power has been given by the Constitution itself. And contempt of court articles 129 for Supreme Court and 215 for High Court. These are the basic things that we need to know, and also Constitution does not define. It only mentions as discussed. We'll move to question number 2. Government law officers and legal firms are recognized as advocates, but corporate lawyers and patent attorneys are excluded from recognition. This also already spoken of. Two statement na join mabuttu, one is this and other is not this. ಈ ತರ ಕೊಟ್ಟಾಗ UPSC usually trap kodutte. So government officers, they are recognized, but these are not recognized or excluded. Ee tara trap kodutte. Second, Bar Council have the power to lay down the rules relating to legal education and recognition of law colleges. This is a correct statement and this is a wrong statement. So, ee tara traps usually UPSC kodutte, we'll have to be very careful. This is where the trick comes in. And another thing is, Bar Council, ನೀವು ಕೇಳಿದ್ರೆ state bar council ಅಂತ ತುಂಬಾ ಸತಿ lawyers, advocates, they keep using these terms because the power, there exists state bar council also, and bar council, it is a statutory body which has the power to formulate legal education and recognize law colleges in India. So the definition of advocates in India, it is been governed by the Advocates Act. So Advocates Act alli, a person who qualifies a certain judicial exam and is enrolled in the bar council, that person is classified as advocate, be it corporate or be it a public prosecutor. So government law officers, they are advocates, yes. Corporate law lawyers are also advocate as per the definition of advocates that we follow in India. So apart from that, even in Advocates Act, state governments are given power. We'll have a look at it. See, bar council also, like I spoke of, see, Advocates Act under state bar councils give power kottidare so that they can formulate their rules. Likewise, there is bar council. Now this bar council is a statutory body which is established under Advocates Act. So bar council statutory body, bar council mele previously question bandidike. In the future UPSC might even ask which of the following are statutory bodies. Adral one of the statements bar council kuda agirbodu. So we need to know this, and bar council can inspect colleges and to see that there is proper legal education that is taking place, and can also formulate regulations related to the legal practices in India. We'll move to question number 3. A bill amending the constitution requires a prior recommendation of the president. See, constitution amendment is a basic topic which we need to know. President prior permission is not needed. In this question, one I eliminate matter directly two answer barutte, but we'll see the other options also. When a constitutional amendment bill is presented to the President of India, it is obligatory for the President of India to give his or her assent. Idu original constitution irlilla, but later through 24th constitutional amendment, it became mandatory for the President to give assent to the constitutional amendment bill. Likewise, look at the third statement. Constitution amendment bill must be passed by both Lok Sabha and Rajya Sabha by a special majority, and there is no provision of joint sitting. Joint sitting is not present when it comes to constitution amendment bill and when it comes to money bill. It is present only in case of the ordinary bill. Whereas when we talk at the state level, there is state legislative assembly and state legislative council in certain states, but council has very less power compared to the Rajya Sabha. So state case alli, even there is no provision for joint sitting in the state case, because if assembly passes a law, then there is no provision for state legislative council to amend or reject it. So state level alli aatara ide, but at the center in the parliamentary level, there is provision for joint sitting when it comes to normal bills, but money bill matte constitution amendment bill bandaga there is no provision for joint sitting. And also here the special majority that it is talking about is, it should be greater than 50% of the total strength, and it should be more than 2/3 of the members present and voting. It is this special majority that it is talking about. And constitution amendment bill alli president assent necessary illa because before introducing it, but when it is been forwarded to the president has to give the assent. And also another thing which I want to mention is, see, constitution na amend madbekandre, how is that we can do? Constitution na amend madbekandre one simple majority alli pass madbodu. This can be done at parliamentary level also. Another one is using article 368. Article 368 na use madre, it comes under special majority. Ee special majority lu two categories ide. One bari parliamentary level alli agade, one parliament plus states. See, if we are amending the constitution by simple majority, then article 368 is not needed, but there are certain provisions which are more rigid to be amended. So for that we'll be using article 368, and for that also there are two categories. ಫಾರ್ ಎಕ್ಸಾಂಪಲ್ ಫಂಡಮೆಂಟಲ್ ರೈಟ್ಸ್ DPSP ಇದ್ರೆ ಸ್ಪೆಷಲ್ ಮೆಜಾರಿಟಿ at the parliamentary ಲೆವೆಲ್ ಬೇಕು. ಬಟ್ ಇಫ್ ಇಟ್ ಈಸ್ ಎಫೆಕ್ಟಿಂಗ್ ದ ಫೆಡರಲ್ ಫೀಚರ್ಸ್ then parliamentary special majority plus half of the states, half of the state governments across the country will have to agree. If that is there, then it can be amended. For example, ಇದರಲ್ಲಿ 7th schedule ಬರುತ್ತೆ. 7th schedule ನ amend ಮಾಡಬೇಕು, GST council ನ amend ಮಾಡಬೇಕು ಅಂದ್ರೆ it will come under this category. Whereas fundamental rights DPSP ನ ಮಾಡಬೇಕಂದ್ರೆ it will come under this category. Simple majority ಅದಕ್ಕೆ there is other things like 5th schedule, 6th schedule. So ಇದನ್ನ ಮಾಡಬೇಕಂದ್ರೆ simple majority through ಮಾಡಬಹುದು. We'll move on to the next question. Same thing which I wanted to spoke of, right? So we'll move to the next question. The Constitution of India classifies, again the same trap. The Constitution of India defines, the Constitution of India classifies, the Constitution of India anta bandaga traps kodtare. It classifies ministers into 4 ranks: cabinet, minister of state, of independent charge, minister of state and deputy minister. Okay, look at the second statement. The total number of ministers in the union government including PM shall not exceed 15% of total number of members in the Lok Sabha. Now one is very simple fact. This has been added by 91st constitutional amendment. So 2 is correct. 1, this becomes wrong. What was the reason beyond adding this? This was added at a time when there was coalition politics. Too many parties used to form coalition with a major party, and major party just to get the confidence of the other parties ತುಂಬಾ ಜನನ ಮಿನಿಸ್ಟರ್ಸ್ ಮಾಡ್ತಿದ್ರು, ತುಂಬಾ ಪಾರ್ಟೀಸ್ ಇಂದ ಮಿನಿಸ್ಟರ್ಸ್ ಮಾಡ್ತಿದ್ರು, ತುಂಬಾ ಡೈವರ್ಸಿಫೈ ಮಾಡ್ಬಿಟ್ಟಿದ್ರು. So that is why there wanted to be a limit to ensure that the total number of ministers including PM will not exceed 15% of Lok Sabha, which we follow even till date. So idu namiga gottiro vishaya. And we know that ministers ali, these are the following types: cabinet minister, minister of state, deputy minister, and all of these they fall under a broad category called council of ministers. See, council of ministers ali cabinet kuda bandru, deputy ministers kuda bandru, and so on. All these form under broad category called council of ministers. But this is a convention or practice that we follow. The constitution itself does not define it. So constitution define madide, classify madide, ee tara statements most of the time wrong e irutte, like in this case also. Also one more important thing, see, cabinet ministers na ನಾವು ಕೇಳಿದೀವಿ, but do we know that whether cabinet is been defined in the constitution or whether it is mentioned in the constitution? Cabinet, the word cabinet is been mentioned in the constitution and it appears only once. ಇದರ ಮೇಲೆ ಕೂಡ direct question formulate ಮಾಡಬಹುದು. One of the statement ಕೊಟ್ಬಿಟ್ಟು the cabinet, the word cabinet appears twice in the constitution ಅಂತ ಕೂಡ statement ಕೊಡಬಹುದು. It appears only one, and that to this cabinet word was added post internal emergency was been declared. Internal emergency declare ಆಗಿತ್ತು, ಅವಾಗ we got to know that the emergency provisions in India, they're not very apt. So that is why 44th 42nd amendment alla ಮಾಡಿದ್ರು. So on the basis of that, cabinet word was been added to ensure that ಈಗ national emergency declare ಮಾಡಬೇಕಂದ್ರೆ only the PM cannot give the permission. You need the written writing and you need the confidence of the cabinet as well. So that is why the word cabinet becomes important, and it is mentioned only once in the Indian constitution. We'll move ahead. Which of the following are exclusive powers of Lok Sabha? Simple question. To ratify the declaration? No. To pass a motion of no confidence? Yes. The ministers or the government of the day, they are only responsible for the Lok Sabha and not for the Rajya Sabha. To impeach the president, both have equal powers. So which are the areas where Lok Sabha has more power? Gottirbeku. Money bill, demand for grant, cut motion, ivelladku Lok Sabha has more power. Even if it is a joint sitting, it is the speaker of the Lok Sabha who will be heading and not the chairman of Rajya Sabha. Likewise, if there is, when there is joint sitting also, there is higher chances that Lok Sabha, whatever it wishes, it will happen, because Lok Sabha has 545 members and Rajya Sabha has around only 245 members. So Lok Sabha ali jasti number idike, usually it wins over the bill when a joint sitting is been held. But joint sitting has been held only 3 times till now, which is a very rare thing. So apart from this, Rajya Sabha also has certain special powers. What are those? We discussed earlier also. All India service create ಮಾಡಬೇಕಾ, Rajya Sabha special majority pass ಮಾಡಬೇಕು. If a parliament wants to make a law on the state list, it is Rajya Sabha which can allow it or initiate it. Vice president na remove ಮಾಡಬೇಕಾ, the motion for its initiation can only be started by Rajya Sabha and then later agreed by Lok Sabha, right? So these are the special powers which Lok Sabha has, Rajya Sabha has. In other areas, both have same powers. Look at the next question with reference to anti-defection law. Anti-defection law ಯಾವಾಗ ಆಡ್ ಮಾಡಿದ್ದು 52nd constitutional amendment. ಇದು ಗೊತ್ತಿರಬೇಕು. The law specifies that a nominated legislator cannot join any political party within 6 months. See, ಯಾವಾಗಲೇ term within, after, before, up, down, decrease, increase, opposite terms ಬಂದಾಗ there is good chance that UPSC could replace the word by the other word. So be very careful. The law does not provide any time frame within which presiding officer has to decide a defection case. Anti-defection does not have a timeline. This is correct. This is one of the biggest criticisms of the office of speaker, that he can take any amount of time to decide anti-defection. In case of Manipur speaker, he had taken more than 4 years to decide the cases of anti-defection. So idu one issue. So speaker office bagge, if you are writing a mains answer, then those students would have come across this, that there is no time frame that has been mentioned in the constitution or in any statute that requires the presiding officer to decide a defection case. So this is correct. The law specifies that a nominated legislature cannot join any political party after 6 months. Sorry, nodi, before, after, we have to be very, very careful when it comes to polity, because a small word can make this question go wrong. 2 marks plus minus 0.66. ಈ ಒಂದು ವರ್ಡ್ ಇಂದ minus 2.66 ಲಾಸ್ ಆಗೋ ಚಾನ್ಸಸ್ ಇರುತ್ತೆ. It is after 6 months. If a person, nominated person, joins a particular political party before 6 months, then anti-defection will not be applicable. But if he joins after 6 months, then it will be applicable. Anti-defection grounds ಗೊತ್ತಿರಬೇಕು. Common grounds, the 4 common grounds everyone knows. Along with that, there is a ground of merger. If a particular party, if 2/3 of a particular members of a party join another party, then that will not lead to anti-defection. But if it is less than 2/3 of the members of a particular party joining another party for the merger, then it will lead to anti-defection. ಇಷ್ಟು ಗೊತ್ತಿರಬೇಕು anti-defection ಬಗ್ಗೆ. And when it comes to anti-defection, it is the speaker who shall be the deciding authority. This is also one of the criticism. We want the anti-defection power to go to the president, who shall decide it on the in consultation with the election commission or Supreme Court. We want that to happen, but it is the speaker who is still deciding it, and speaker himself is a partisan person, so it becomes sort of contradictory. Okay, anti-defection law, 52nd amendment, no time frame, same thing which we discussed. Next question. Attorney General of India, Solicitor General of India are they are the only officers of government who are allowed to participate in the meetings. According to the Constitution of India, Attorney General submits his resignation when the government which appointed him resigns. Okay, this is wrong, and so is this. How? Attorney General is a constitutional office which is established under Article 76, and Attorney General, he enjoys the parliamentary privileges which is been provided under Article 105. Parliamentary privilege ಯಾರ್ಯಾರಿಗೆ extend ಆಗುತ್ತೆ? Prime Minister, Council of Ministers, and Attorney General. President and Vice President do not enjoy parliamentary privileges. ಇದು ನಮಗೆ ಗೊತ್ತಿರಬೇಕು. So Attorney General has the right to participate in the meetings of the Parliament. This is a privilege which has been given to the Attorney General. It is not present for the Solicitor General. So ಇಲ್ಲಿ ಬರೀ Attorney General ಇದ್ರೆ statement correct ಆಗುತ್ತೆ. Solicitor General ನ club ಮಾಡ್ಬಿಟ್ಟಿದೆ. That's why it becomes wrong. According to Constitution of India, Attorney General of India submits his resignation when the government which appointed him resigns. This is a normal thing that will happen, but it is not mandated. Government of the day, whichever person is closer to him, they would appoint him as the Attorney General. And if the government falls, the Attorney General could be made to resign. But if the next coming government also has good relation with the Attorney General, then it will lead to continuation of the office. See, the office of Attorney General, though it is constitutional under Article 76, it does not have a security of tenure. Fixed term anta illa. Attorney General holds office during the pleasure of the president. So president ಯಾವಾಗ ಬೇಕೋ ಅಪಾಯಿಂಟ್ ಮಾಡಬಹುದು, ಯಾವಾಗ ಬೇಕೋ ತೆಗಿಬಹುದು. He does not have a security of tenure. This is one of the criticism of the office of Attorney General, because his independent functioning might be affected. And one more thing, Attorney General can do private practice also along with fighting government litigations. There isn't a bar where he cannot participate himself in private practices. and Attorney General is not an office under central government, it is an independent constitutional post. Idu namage gottirbeku. Suppose government of the day will ask Attorney General to fight a particular case. Attorney General, if there are sufficient grounds, then Attorney General can even deny to fight the case of the government. E power kuda Attorney General ಗೆ ಇರುತ್ತೆ. This is what commonly we miss it. So I wanted to tell. See, same thing, Attorney General Article 76 under provide ಮಾಡಿರುತ್ತೆ. President will appoint. He does not have a security of tenure, holds pleasure, and but there are certain things like Attorney General should not defend accused person in criminal prosecution. Criminal cases bandaga he should not defend the accused without the permission of the government, because it could also bring a bad name to the government. Whereas when we are talking about the Solicitor General and Additional Solicitor General, these officers, they help Attorney General, but Solicitor and Additional Solicitor, they are not constitutional post. Article 76 Attorney General ಬಗ್ಗೆ ಮಾತ್ರ ಮಾತಾಡುತ್ತೆ, other two post ಬಗ್ಗೆ ಮಾತಾಡಲ್ಲ. So Solicitor General and Attorney General, they are neither statutory nor constitutional posts. They have been established under an executive resolution. Executive resolution, they are established under rules. Solicitor General and Additional Solicitor, they have been established under Law Officers Condition of Service Rules 1987. Idr mele inno question bandilla, so this becomes important. And Solicitor General has a term unlike Attorney General, and they have a term of 3 years. They are appointed for a term of 3 years. They have a fixed term. And Solicitor and Additional General, they do not have the right to participate in parliamentary proceedings because they do not have parliamentary privileges like Attorney General has. So that is why they cannot participate. Similar thing, Article 76 under hegitto, same at the state level, there is Advocate General under Article 165. So whatever powers apply to Attorney General, similar things will apply to Advocate General at the state level. Simple thing. We'll move into next question. With reference to writs issued by the courts in India, which of the following are correct? See, writs and bandaga commonly we get confused. We know writs can be issued only by Supreme Court and High Court, but which are those 5 writs? Idan ಜ್ಞಾಪಕ ಇಟ್ಕೊಳ್ಳೋದು, ಆರ್ಡರ್ ಜ್ಞಾಪಕ ಇಟ್ಕೊಳ್ಳೋದು ಕನ್ಫ್ಯೂಷನ್ ಆಗುತ್ತೆ. So usually how we can remember it? Her Maggie pay chicken Qureshi. Her Maggie pay chicken Qureshi. This is how I remembered. You can use any mnemonic that you want. Habeas corpus mandamus, prohibition, certiorari, quo warranto. Right, so they are talking about mandamus. So mandamus means, the term means we command. So the court is asking a public official to perform his duties well, which he has failed to do. So it public official mele court helo vishya normally seen. So mandamus will not lie against a private organization unless it is entrusted with a public duty. Okay. Mandamus will not lie against a company even though it may be a government company. See, even though one extra term kodtare UPSC, they give that extra thing to make it wrong, right? And also see statement 1 and statement 2, what is that you can understand? In statement 1 it is telling, even if it is a private organization, if it has been entrusted with a public duty, then mandamus will apply. Statement 1 adanne heltide. Statement 2 ಏನು ಹೇಳ್ತಿದೆ? Statement 2 ಹೇಳ್ತಿರೋದು even if it is a government company, then mandamus will not be applicable. So statement 1, statement 2 are exactly contradicting each other. So simple words ಹೇಳಿದ್ರೆ statement 1 ಮತ್ತೆ statement 2 cannot be together. Any public minded person can be a petitioner to move the court to obtain the writ of quo warranto. Quo warranto is an easy thing we need to know. Quo warranto, it is used to see the legitimacy of a person who is holding a public post. Is it legitimate or not? Idana check madakoskara court will issue the warrant, and any person can file it, not just the person who has been victimized. So quo warranto does not apply to ministers because quo warranto applies to those posts which are permanent in character. So bureaucrats ಗೆ apply ಆಗುತ್ತೆ, ministers ಗೆ apply ಆಗಲ್ಲ. Likewise mandamus is applicable. Where is it applicable? It is applicable to private organizations if they are fulfilling any public duty. It is applicable on government companies. It is applicable on public officials. But mandamus shall not be applicable if the matter is being dealt with a particular court, or if the matter is being dealt by president or governor or vice president, or if the matter that is been dealt has already been covered by a particular statute. So statute ಅಲ್ಲಿ ಇರೋ statute ಪ್ರಕಾರ ಹೋಗುತ್ತೆ, ಆವಾಗ mandamus ನ ಇಶ್ಯೂ ಮಾಡಕ್ ಆಗಲ್ಲ. ಸೊ ಸಿಮಿಲರ್ ಥಿಂಗ್ ಹೇಬಸ್ ಕಾರ್ಪಸ್ ಬಗ್ಗೆ ಗೊತ್ತಿರಬೇಕು, ಪ್ರಾಹಿಬಿಷನ್ ಬಗ್ಗೆ ಗೊತ್ತಿರಬೇಕು, ಸರ್ಚರರಿ ಬಗ್ಗೆ ಗೊತ್ತಿರಬೇಕು. This is an important topic and UPSC has asked good questions over it. QRNTO, mandamus, these things. And like I spoke of, who can issue writs? Only High Court and Supreme Court can issue writs. Subordinate courts as of now cannot issue writs, but the Parliament has the power to even empower the subordinate courts to issue writs, but the Parliament has not yet done it. Right. With reference to Deputy Speaker of Lok Sabha, as per the rules of procedure and conduct of business of Lok Sabha, the election of Deputy Speaker shall be held as the Speaker may fix. This is correct. Who decides the date of election of Speaker? It is the President. Who decides the date of election of Deputy Speaker? It is the Speaker who decides. And this convention and this thing is been mentioned in rules of procedure of Lok Sabha. So Deputy Speaker date na Speaker fix madodu. This is a correct statement. This we need to know. There is a mandatory provision that the election of a candidate as Deputy Speaker shall be either from the principal opposition party or the ruling party. See, statements are wrong madak avare trap kodtare. There is a mandatory provision. They will give that extra thing. So ee word bartidange extra cautious agbeku. Mandatory provision, the Deputy Speaker shall come from principal opposition party or the ruling party. Though that is not been mentioned. So usually up to a particular time yenagittu, until the 11th Lok Sabha, Deputy Speaker was from the ruling party, and later there came a conventional practice that the Deputy Speaker post 11th Lok Sabha shall be from the opposition party. So this is what is a conventional practice. It has not been backed by any constitutional article or a legislative mandate. So there is a mandatory provision another wrong. 2 wrong andre idu wrong agate, B wrong agate, D wrong agate. So the remaining option is A or C. So statement 3 correct. Deputy Speaker has the power, same power of Speaker when presiding, and no lie, no appeal lies against his rulings. Okay. Statement number 4. The well-established parliamentary practice regarding the appointment of Deputy Speaker is that the motion is moved by the Speaker and duly seconded by the Prime Minister. ಇನ್ನೂ ಒಂದು ಏನಂದ್ರೆ ಈ ತರ ಎರಡೆಡ್ ಆಫೀಸಸ್ ಅಥವಾ ಈ ತರ ಎರಡೆಡ್ ಟರ್ಮ್ಸ್ ದಿಸ್ ಪ್ಲಸ್ ದಿಸ್ ಅಂತ ಕೊಟ್ಟಾಗ UPSC ಟ್ರ್ಯಾಪ್ ಕೊಡುತ್ತೆ. ಸ್ಪೀಕರ್ ಡೆಪ್ಯೂಟಿ ಸ್ಪೀಕರ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆಗ್ಬೇಕಂದ್ರೆ ದ ಮೋಷನ್ ಇಸ್ ಆಕ್ಚುಲಿ ಮೂವ್ಡ್ ಬೈ ದ ಮಿನಿಸ್ಟರ್ ಆಫ್ ಪಾರ್ಲಿಮೆಂಟರಿ ಅಫೇರ್ಸ್. ಸೊ ಹಿ ಇಸ್ ದ ಪರ್ಸನ್ ಹೂ ಶಲ್ ಮೂವ್ ದ ಮೋಷನ್. It is not the Speaker or the Prime Minister. So ಈ ತರ ಫಸ್ಟ್ ಇವನು ಸೆಕೆಂಡ್ ಇವನು, ಸಿ ಹೌ ಮೆನಿ ಪರ್ಮಿಟೇಷನ್ಸ್, ಫಸ್ಟ್ ಬೇರೆಯವ್ರು ಕೂಡ ಆಗಿರ್ಬೋದು, ಸೆಕೆಂಡ್ ಸ್ಪೀಕರ್ ಕೂಡ ಆಗಿರ್ಬೋದು, ಈ ತರನು ಥಿಂಕ್ ಮಾಡಬಹುದಿತ್ತು. ಸೊ ದೇರ್ ಆರ್ ಸೋ ಮೆನಿ ಪರ್ಮಿಟೇಷನ್ ಕಾಂಬಿನೇಷನ್ ಇನ್ ವಿಚ್ ಸ್ಪೀಕರ್ ಅಂಡ್ PM do not fit in. 4 is wrong. So C becomes wrong. 1 and 3 becomes the answer. Even if we knew that 1 is correct, we would have directly got option A as the answer even without looking at statement number 4. See, Deputy Speaker, date of election of Deputy Speaker fixed by the Speaker, and Deputy Speaker shall exercise the same power as a Speaker when he is in the office. So well established parliamentary practice, motion for the Deputy Speaker election is moved by Parliamentary Affairs Minister and it is seconded by the Treasury bench or by the opposition. So tumba non conventional questions na ee tara formulate ಮಾಡುತ್ತೆ just to see your understanding, because obviously speaker deputy speaker election ge motion who would have supported it first, who would have supported it second, ee taradna ನಾವು ಓದಲ್ಲ. So UPSC will give such questions just to see even if you are able to understand whether it is right or wrong. ಒಂದು ಸ್ಮಾರ್ಟ್ ಗೆಸ್ ತಗೊಳಕ್ ಆಗತ್ತೆ ಇಲ್ಲ ಅಂತ ಕೂಡ UPSC will try to test the candidates in this way. We'll look at the next question. If a particular area is brought under 5th schedule of the Constitution of India, which one of the following statements best reflects the consequence? They are talking about 5th schedule. Confuse agbedi. 5th bere, 6th bere. 6th alli there are 4 states which we know about: Assam, Meghalaya, Tripura and Mizoram. So idu namige gottide, but they are talking about the 5th schedule. So this would prevent the transfer of land of a tribal people to non-tribal people. This is correct. This would create a local self-governing body. Fifth schedule alli local advisory body agate. Local advisory body agate. Whereas sixth schedule alli local autonomous body agate. So the kind of body that this is talking about, it comes under sixth schedule, or local self-governing body means PRS tara it's talking about. This would convert that area into union territory. Totally wrong, made up thing. The state having such areas would be declared as special category under Article 371. This is also made up thing, which is not at all related. So fifth schedule means there are certain states where substantial amount of tribal population exists. India likewise there are 10 states which fall under fifth schedule. So certain part of the state alli these areas are found where there are good number of tribal people. So it is the president who shall declare such parts of the state to be scheduled areas. So those areas would come under fifth schedule. So fifth schedule certain special provisions kodate to protect the tribal rights. One is tribal advisory council formulation. Another one is governor will have more powers. State government certain acts madate, parliament certain acts madate. But will it be applicable on scheduled areas? Yes, but the governor will ensure that those regulations of the parliament or state legislature shall be applicable, but it shall be applicable only if it suits the tribal practices. So governor ge power ide. Governor can even make regulations to fifth schedule areas. These powers are there. Also another thing is with respect to the land. Fifth schedule areas alli the land that the tribals possess, these are Adivasi land. So these Adivasi land cannot be acquired or purchased by non-Adivasis. This is one of the protection that has been granted under fifth schedule. But if a non-Adivasi wants to sell it land, that would by default go to or only be purchased by a Adivasi. This is also another provision that has been provided. So 10 states anta helindalla, we should know about the 10 states where the fifth schedule is applicable. Fifth schedule areas, see Assam, Meghalaya, Tripura, Mizoram, sixth schedule. Adin bittu 10 states enide adu fifth schedule under barate. So like I said, tribal advisory council it will provide. So whatever regulations the governor will make, he will make it in consultation with the tribal advisory council. Governor can direct any act of parliament or state legislature to apply or not apply based on whether it suits the tribal features or whether it affects the tribal way of living. Governor can also make regulations, similar thing. And like I said, a land in scheduled area, a land in fifth schedule area is presumed to be a Adivasi land. Hence, not only should no land should pass into hands of non-Adivasis, but also any land presently that is been owned by a non-tribal, if it is been transferred, then that should come to the hands of STs. This is one extra fact. Idunna now common we do not come across. That is why I wanted to talk. And there are 10 states where the fifth schedule would be applicable. Idu namige gottirbeku. See, one way of remembering it is 10 states. India map na ಜ್ಞಾಪಕ ಇಟ್ಕೊಂಡ್ರೆ we can remember those 10 states. India map na ಜ್ಞಾಪಕ ಇಟ್ಕೊಂಡಿದ್ರೆ we can easily remember those 10 states. See, almost all the states which come under this region, 9 states under this region plus Himachal Pradesh here. These are the 10 states. So ee region lo baro state yadyadu? Gujarat, Maharashtra, Madhya Pradesh, Karnataka ಮೇಲೆ ಯಾವ್ದು ಬರುತ್ತೆ ಎಲ್ಲ, ತೆಲಂಗಾಣ, ಆಂಧ್ರ ಪ್ರದೇಶ್, ಛತ್ತೀಸ್ಗಢ, ಒಡಿಸ್ಸಾ, ರೈಟ್, ಮಧ್ಯಪ್ರದೇಶ ಆಯಿತು, UP ಬಿಹಾರ್ ಬರಲ್ಲ, ಛತ್ತೀಸ್ಗಢ, ಒಡಿಸ್ಸಾ, ಜಾರ್ಖಂಡ್. So likewise along with this Himachal Pradesh. So like this way we can remember those 10 states. So this was about the discussion. This was about the discussion about the 2022 CSE Prelims Polity questions. Thank you for watching. I hope you enjoyed it.